All real property and some personal property, such as vehicles, are titled, meaning that documentation of ownership is filed in government records. The California Family Code recognizes four ways in which spouses may hold titled property, namely as tenants in common, joint tenants with a right of survivorship, community property, or community property with a right of survivorship. Regardless of title form, the property will be presumed to be community property in a dissolution proceeding. But title form impacts spouses' rights during marriage and upon a spouse's death. Let's take a closer look at each title form. In a tenancy in common, each spouse owns an undivided share of the property and is simultaneously entitled to possession of the whole property. The spouse's shares don't have to be equal, and each spouse may freely transfer his or her interest to a third party and may devise it, meaning leave it to a designated person in a will. If a marriage ends in dissolution, then the property will be presumed to be community property. But if a marriage ends with a spouse's death, then the property is presumed to be concurrently held separate property. As an example, imagine that a husband and wife purchase a ranch with the husband using separate property to pay two-thirds of the purchase price, and the wife using separate property to pay one-third. They title the property with themselves as tenants in common. Each spouse owns a share of the ranch, and even though the shares aren't equal, the spouses are each entitled to use the whole property. If the spouses divorce, the property will be presumed to be community property. But if the marriage ends with one spouse's death, then the property will be presumed to be concurrently held separate property. The deceased spouse's share will be distributed as part of his or her estate.